Well, money, inheritance, greed, family, and betrayal. Our next guest has witnessed those pitfalls and many others in his decades as a wills lawyer. Les Kotzer is here to help us with some important lessons of creating a will and what we might want to avoid. Welcome to Your Morning.
Thanks for having me, Emily.
First of all, you say wills and inheritance can bring out the worst in people. So let's start with the basics. Who should have a will and why?
Well, everybody over the age of 18 in Ontario or other jurisdictions that have different maybe ages should have a will. And there are a lot of young people out there that have inherited a lot of money from their grandparents, and et cetera. They figure, I'm 18, I don't need a will, it's only for old people. That is not true. Without a will, in Ontario, for example, the government writes the will for you if you don't have a will. Your beneficiaries are not who you want. Your spouse gets the first $200,000, and the kids will split the rest with the spouse. There's no executor named if you don't have a will. There's no guardian name for your young children if you don't have a will. And also, every will that I do, I put in a clause that protects your son and daughter in case they inherit your money and later get separated and divorced. Well, without a will, your daughter-in-law or son-in-law could benefit from your children's inheritance. By having a will and having the proper clause in it to protect it, they won't get anything.
What is the difference between a will and a power of attorney?
Well, a will takes effect after your death. A power of attorney is while you are alive. So the power of attorney protects you in case you're incapacitated through an accident or illness. And there are two power of attorneys. One is a financial power of attorney that allows somebody you trust to step in and manage your finances, your house, your bank accounts, your business. It stops the government from stepping in to manage your assets, and it must be done correctly. Otherwise, the government can step in. It must be what's called a continuing, and a power of attorney that covers everything you own. Then there's a medical power of attorney, one where you're allowing somebody to be appointed to act for you medically, like your son, your daughter. Power of attorney doesn't mean you appoint your lawyer. It means you would appoint somebody you trust. Then there's the will. The will only takes effect when you die. The power of attorney dies with you. And then your executor in the will is appointed. That executor looks after your estate and does deals, pays the bills, distributes the assets to who you left them to. You can name a guardian in your will to raise your children. What if you and your spouse are killed in a car crash? Who's going to raise your children? I don't understand how young parents sleep at night without having a will. There's no guardian name for their kids. And then also the will distributes your assets to who you want them to. All your years of hard work, where do you want them to go? Because without a will, the law sets out who gets your money.
Is there ever a time when someone shouldn't have a will?
Well, according to what I've been reading, 50% of Canadians don't feel a will is necessary. And I can tell you it is necessary. And it's not just the 50% that don't have a will, it's those that have bad wills. One of the things I do in my practice is I do free reviews of wills, and I see a lot of wills and powers of attorney that are no good, that are recipes for family disaster or for family war.
Let's say you have a will before you get married. Is it true that the marriage will then revoke your will?
Yes.
Or does it stand?
Marriage revokes a will.
Oh.
But the separation does not revoke a will. So if you're separated, you need to make a new will because the person named in your will as your spouse is still your spouse, even though you're separated. Divorce does not revoke your will. It only revokes the name of your spouse in the will. And one thing that's important, common law in Ontario, if you die without a will, your common law partner is not entitled to an inheritance. People think they are not. They have to make a claim for support. So if you're common law, make sure you do a will.
Good to know, even just these basics as we're looking at an important topic. 50% of Canadians without a will.
That's right.
Good to have you here this morning.
Thanks so much for having me.
All right, Les's fourth book is called Wills, Money, Inheritance, Greed, Family, and Betrayal, and it is available online. Thanks for watching. If you like this, be sure to subscribe here.
And you can check out more Your Morning videos right here.